This video is a very brief overview of anti-discrimination law in Australia. Anti-discrimination law by itself could be a whole elective, and there are a lot of cases and a lot of interesting stuff to look at. What I propose to do is just outline how the scheme of anti-discrimination legislation relates to gender and women. And if you're interested, please do more research and have a look at some of the case law in more detail. So basically, originally, if you remember, there was very much an ideology that women were to be in the private sphere and men in the public sphere. This had led to women being systematically discriminated against on the basis of wages, working conditions, reasons for firing, being sexually harassed, etc. There was an enormous amount of work by feminists from a lot of different streams of feminism looking at trying to prevent this sort of discrimination. And discrimination law was used very successfully to break down these entrenched discriminations and to try to break down the stereotypical assumptions of who worked and who was in the workplace. It's also been extended to look at other things like housing, education, etc. It was one of the key successes of liberal feminism to use the law to actually change the status of women in society and to prevent discrimination against them. The aim, however, is very typical of small L liberal theory in that it is to look at the position of an individual and to remedy an individual wrong, not necessarily to create systemic change or to punish wrongdoers. It's very much about compensating the person who's been discriminated against. There has been some level of systemic change that's gone hand in hand with discrimination law, in that various anti-discrimination commissions at various levels do research, publish materials, advertise to try and remove and reduce discrimination, and also take reports and sometimes name and shame some offenders. However, overall, it is a confidential system which is about remedying individual harms. Part of the issue today is that there's often difficulties in proof of discrimination. It was easy back in the early 80s when the legislation was first created at the Commonwealth level, where people were still saying stupid things like, we're not going to hire you because you're a woman. People don't do that as much today. And sometimes it can be subtle, though not always. There are still some real wallies out there. There are also arguments that these are special measures, but on the other hand, when you see people who are not necessarily from dominant genders working in a range of spaces, and if you see them as normal humans, then this suddenly becomes less of a special measure, but some people see them as special measures. One thing that's interesting about discrimination law is how it has affected our normative presumptions. It's both made a huge difference and then reinforced the normativity of the male worker in some ways. So there's arguments either way. It's certainly made some huge differences in that today, you and I would not assume that women would automatically be paid less than men for the same job. We would not assume that the law would entrench such a ridiculous thing. We would not assume that it's normal or okay to sexually harass co-workers. All of these normative shifts have come about in part because these things have been made illegal or against the law, and they can actually hurt the bottom line of companies. And there was a lot of pushback to this when the anti-discrimination law was first passed. However, so it has a huge normative effect in that we have changed our assumptions of what it means to be in a workplace with diverse genders. At the same time, the legislation, as you will see, generally requires us to look at the person who claims discrimination and compare them to some sort of standardized worker who often ends up being a white man, and then seeing if the harmed individual was treated less well than our standard worker. So it, in some ways, re-entrenches men and white men and cisgendered men as the normative worker that we compare all others against, who are departures from that normative position. So that's one of the critiques. Though having said that, I actually think this legislation has made a huge change in society. The way most of our anti-discrimination legislation works is that they start with a process of alternative dispute resolution, usually called conciliation. And at the national and state level, approximately 98% of matters are actually settled in conciliation. We don't know, other than at the general reporting level for commissions, what the outcomes are of these vast majority of complaints. They are not reported individually and they don't form precedents. 2% only proceed beyond conciliation to the commission, and even a smaller percentage end up in a court process. So it is very privatised. It is something that if there is normative responses, it's not being spread beyond one company or one set of complainants and responders. Having said that, some people feel that conciliation is better for the complainants. Someone like Carol Gilligan, who we looked at in our theory section, would actually argue that this actually takes into account that type of ethics of care, internalisation of morality that she identified as being something that many women would prize and value, in having flexibility, in allowing an emphasis on relationships, and maybe even retaining or fixing some relationships. However, there isn't much, there isn't a formalised process that can do a huge amount about the power imbalance between often an unemployed person who has lost their job or faces losing their job if their complaint is not held up, and a larger employer organisation, particularly very large companies. And this can influence a lot of things, including access to resources, either access to legal representation or investigation, etc. Access to information. Often the employer is the one with the records, and the employee, unless they have kept careful records over time, may not have full information about their employment status and complaints, etc. At the ADR level, it's quite informal and discretionary, which means that there's often not the formality of a court, which can itself act as a protection and a correction of some level of power imbalance. And there is issues around use of language patterns and verbal space between more dominant persons and persons who've been discriminated against, particularly women versus men, but also women versus employers generally, where if you remember from other videos, there have been studies such as by Spender, who said that there can be a perception that if a woman talks more than 30% of the time, she is taking up a disproportionate over half amount of verbal space, such that this may lead unconsciously to particularly female or female presenting persons being silenced because of a perception they are otherwise dominating. So how do the acts work? Basically, I'll start with the Sex Discrimination Act. Here are our objectives of the Act. You can see that it is to put in place provisions of the Convention on the Elimination of All Forms of Discrimination against Women. It intends to attempt to eliminate discrimination on the grounds of sex, sexual orientation, gender identity, intersex status, marital or relationship status. That was very important because at one stage women would be fired for being married or could be refused jobs for being in a de facto or unmarried relationship. Pregnancy or potential pregnancy, again, women used to be fired for being pregnant, or women may not be hired because of the potential for pregnancy in some places, or breastfeeding. And then we look at that in areas of work, accommodation, education, provision of goods, facilities and services, the disposal of land, activities of clubs, and administration of Commonwealth laws and programs. So as you can see, there's a range of things. There is also discrimination on the ground of family responsibilities, but that is only relevant in the area of work, not in accommodation, education, etc., etc. Discrimination involving sexual harassment in the workplace, education, and other areas of public activity. But again, as you can see, somewhat more limited than some of the other issues, and to promote recognition and acceptance of the equality of men and women. So the scheme is that, one, you have to identify the ground of discrimination. So you can see the list there. If you are one of those people who that relates to, then you move on to step 2 and you show, for example, if you're arguing discrimination on the basis of sex, were you discriminated in one of these listed areas from part 2? Work, accommodation, education, the provisions of goods, facilities and services, the disposal of land, the activities of clubs, and the administration of Commonwealth laws and programs. So it doesn't cover everything. It only covers these areas. And again, family responsibility as a ground is only for work, and remote residence is only a factor in large resource projects. Then, after you've identified that a ground of gender discrimination applies to you, and then an area of discrimination covers the thing you say you were discriminated against, you have to look in Part 2, Division 4 for exceptions, and there are a lot of them. Many types of religious employer and organisation have exemptions for a lot of their activities. So, for example, a person may be refused to be allowed to work in certain types of religious schools because of their gender identity or their family relationship status, etc. There are other exceptions for clubs, and in particular sporting programs. There are some exceptions that relate to areas where there is a requirement for a person of a particular gender to deal with unclothed or partially clothed persons of particular genders. So you could hire a woman to fit women's clothes or underwear in a fitting room circumstance, or a man in a men's clothing circumstance. You can also match gender to roles for actresses actors. There's me being an old fogey, for people who are representing persons of certain genders. Interestingly, there's been a lot of history of trans people not being portrayed by trans people, and that is something that gets critiqued a lot and doesn't seem to be of much concern as some people otherwise get very hung up on women playing women, men playing men. So you have to look through those exceptions. There's quite a few of them. The other thing to note in this scheme is there's relatively few offences. Most of them have very low penalties. The offences tend to deal with particularly egregious breaches of this, or failure to report if required, etc. The conciliation process under the Commonwealth Act is with the Australian Human Rights Commission, and that can be then, after that process has taken place, and if it ends up in court, it's in the Federal Court or the Federal Circuit Court. Queensland has a very similar scheme. Here's the objects of our Queensland legislation. And as you can see, once again, you have to pick a ground of discrimination for an area or type of discrimination, and as set out for an area of activity. Here are the grounds of discrimination under the Queensland legislation. You can see the Queensland legislation actually covers more than gender issues. The Queensland Act actually also covers areas that the Commonwealth covers under separate legislation, such as race discrimination and disability discrimination. We include things such as lawful sexual activity, asexuality and gender identity, as well as sex, relationship status, pregnancy, breastfeeding, parental status. We also include age, which is something that is less covered by Commonwealth legislation, because the Queensland level legislation did not require the Foreign Affairs power under the Constitution to enable it to pass legislation. For those of you who haven't done constitutional law yet, the reason the Sex Discrimination Act refers to the Convention on the Elimination of All Forms of Discrimination Against Women is that our Commonwealth government can actually gain power to make legislation where it has signed an international treaty or convention. And while before that, it may not have had the power to, well, it didn't have the power to legislate in relation to sex discrimination. Once it signed the convention, it could then put that into domestic law. Don't worry, you'll learn all about it in constitutional law if you haven't done it yet. But our states don't require that. They have whatever power is left that the Commonwealth does not have only for itself, or in areas where the Commonwealth has not made exclusive legislation. Though there is some stuff around acts being void to the extent of inconsistency, but you will note that the Commonwealth Act actually sets out that the state acts are not void, where they have slightly different scopes. The types of discrimination are either direct or indirect. Direct discrimination is a direct choice to discriminate based on the factors, the areas, gender, sex, race, etc. Indirect discrimination, as it's defined there, is discrimination on the basis of an attribute that happens where a person imposes or proposes to impose a term with which a person with an attribute does not or is not able to comply, and with a higher proportion of people without the attribute are able to comply, and that is not reasonable. An example of, classic example of this was height restrictions. So, for example, if you say that all police officers must be 180 centimetres tall, women and persons of Asian descent are less likely to be 180 centimetres tall than men, unless you could show that it is reasonable and that persons under 180 centimetres could not do the job, then that would be indirect discrimination. In the US, there have been other cases where, for example, they have some similar-ish legislation in some states, and where a person, for example, imposes a condition that someone must have a college degree, where that is not actually required for the job. That used to be done in some circumstances because, particularly up until the late 20th century, a higher proportion of white people had college degrees than persons of colour, and in particular African Americans. So you would see cases where, for example, there was a requirement for a college degree to become a janitor and mop the floor, because that indirectly prevented more black people from applying and being able to get the job than it did white people. It was a particularly insidious form of discrimination that has been struck down in a range of US cases. There have been others though. So one thing to be careful of is our comparator. How do we know you're being discriminated against? You compare the person who says they've been the subject of discrimination, again, as I said earlier, against a normative person who does not share their ground of discrimination. And picking that comparator can be really, really important. In a disability discrimination case, Purvis in New South Wales, what had happened was that a child who had an acquired brain injury was substantially more likely than his peers to act out, and often to act out violently against his peers and teachers if he wasn't coping in school. He was excluded from a school by the New South Wales Education Department. And the issue then became, was he excluded because of his disability? Because his acting out was caused by his disability. And the court said, well, what comparator do we look at? Purvis's lawyers said, you look at a well-behaved student versus this student because his behaviour is an effect of his disability. The New South Wales government argued, no, you look at this student versus another student who does not have his disability but who shows the same behaviours. The court actually sided with the state, and they said the appropriate comparator was another student who behaved violently but who did not have an acquired brain injury, and Purvis, who behaved violently because of his acquired brain injury. And they said, is he treated less well than a student without his disability who shows the same behaviours? And they said, no, he wasn't. The other student, if another student behaved the same way, they would also be excluded. You can see there's some real scope for critique of that. So it's very, very important to pick your comparator. Sometimes that's easy. Are women being fired, when they get pregnant versus are men being fired when they're not pregnant? And that's something that can't happen to the majority of men unless they're trans. But in other situations, especially in situations around mental illness and certain types of disabilities, it can be very difficult. So then in Queensland, we also look at our areas of discrimination. As you can see, they are relatively similar to what you see at the Commonwealth level, though we do add between local government members, and we don't have provisions for remote work FIFO situations. In addition, there is an obligation of reasonableness, and here's what you look at for what is reasonable. Whether a term is reasonable depends on all the relevant circumstances, including, this is not limiting it, the consequences of failure to comply, the cost of alternative terms, and the financial circumstance of the person who imposes the condition. So effectively, you're looking at what happens if you don't put in the ramp. Is there another alternative? It might be putting in an elevator for someone who has a disability. And who has to do that? If it's a really big organisation like a huge uni or something, or a large corporate entity, then the financial circumstances will make it much more likely you have to make changes to assist people. Around gender, a lot of the changes are less expensive than some of the disability issues, and it may include training, etc. So they look at small entities. Will still sometimes have to do this stuff, but certainly larger entities are more likely to be found to need to change and spend to comply. So that's it for our schemes of anti-discrimination law. Do look at the case law. There's been some really interesting stuff in various cases. I know we take a lot of this stuff for granted now. I could have romped you through all the case law, but I did promise that we would have some slightly lighter coverage in our case studies for feminism, because we have a lot of reading in the theory section. So that's it for discrimination law.